Welcome back to my YouTube channel. My name is Mokemba Gift. I'm a lawyer and the founder of The Legal Critic. In today's video, I'll be talking about the continuation of the Violence Against Persons Prohibitions Act of 2015. If you know you've not watched my previous video where I talked about the first sector of the Violence Against Persons Act, please do well and go watch the video, as it will help you to understand what I was saying and also to understand this same video. Also, don't forget to subscribe to my YouTube channel if you've not subscribed, as I'll be bringing to you some enlightening and amazing information to keep you abreast with the laws of the Federal Republic of Nigeria. Don't forget to turn on your notification post so that you'll be the first to know whenever I make a content of this nature. Thank you very much and stay tuned on my next video. See you. Okay guys, like I said before, this video is the continuation of the Violence Against Persons Act in the previous video. Now, like I said before, the Violence Against Persons Act was enacted with the aim of eradicating all forms of violence, both in private and public life. In this video, I'll be continuing from chapter 22, as the previous chapters were already discussed in the previous videos. Stay tuned as I bring to you these sections. Section 22 provides that it is an offense for someone to intentionally administer a substance into another person's body or make the person take a substance with the intention of overpowering that person in order to commit any sexual activities. What does this mean? This means that it is an offense for you to either inject any poisonous substance or maybe a pill to make the person sleep or lose consciousness in order to have any sexual intercourse with that person. Where this occurs, the person who committed that action or that offense will be liable on conviction for a term not exceeding 10 years or a fine of 500,000 or even the imprisonment and the fine. This is a very serious offense. All those guys that will take a lady to maybe a restaurant and administer a substance in order for the lady to lose consciousness and maybe they'll take advantage of that lady. Know you today that it's an offense, and if you're caught and found liable, you're entitled or you're liable for a term of imprisonment of 10 years or even both a fine of 500,000 and the imprisonment, or any of them depending on the circumstances of the case. So where anybody use any chemical or any harmful substance in order to make someone loses his or her consciousness and you have sexual intercourse with that person, you're liable to an imprisonment. And where you attempt to do that and you're caught, you're also liable on conviction for a term of 8 years or with an option of fine of 500,000. So whether you do the act or you attempted to do the act and you were caught, you will be held liable. Section 23 talks about political violence. Political violence is defined as any acts of violence that is done in the course of political activities such as elections. The act states that a person who commits any act of political violence is liable on conviction for a term not exceeding 2 years or for a fine of 300,000. So during election, if there is anyone that commits any offense that is tagged political violence, such person shall be liable on conviction for a term of imprisonment of 2 years or below. It is also an offense to willfully have carnal knowledge of another person within the prohibited degree of sanguinity or affinity, and such person shall be liable on conviction to a minimum term of 10 years without an option of fine. Where two parties consent to commit this, they shall be liable on conviction of 5 years. What does this really mean? Having carnal knowledge or having sex with someone that is either in the degree of affinity or in the degree of consanguinity is a criminal offense. Consanguinity means someone related to you either by blood, while affinity means someone related to you by marriage. So knowingly and willfully having carnal knowledge of someone related to you either by blood or by marriage is an offense. And where you're liable, you're convicted or you pay a fine of 300,000. Section 26 provides that anybody who intentionally exposes his or her organs or any substantial part of his or her body with the intention to cause distress to another person, or to make such other person seeing that exposed body be tempted or induced to commit an offense, that person commits an offense called indecent exposure and is liable on conviction. So all these slave queens exposing their bodies, exposing their vital organs with the intention to cause distress to another party, it's actually committing an offense. And when you're taken to the police and you're convicted and found liable, you shall be convicted for a term not less than a year or for a fine of 500,000. As funny as this section may sound, many people do not know that exposing their body, they are actually committing criminal offense. Like if you expose your body in a way that causes distress to another person, you're actually committing a criminal offense, but people do not know. Now, by virtue of the Violence Against Persons Act, today you should know that exposing your body in order to cause distress to another person, you're actually committing an offense. Whenever you feel threatened of imminent danger, such victim can apply to court to obtain a protection order. And this order shall be effective throughout the Federal Republic of Nigeria. So whether you feel threatened by your ex, or maybe your spouse, or anybody that you feel is threatening you, you can go to court and apply for what we call protection order. However, this is only obtainable in the Federal High Court, Abuja. But then when you get the order, it's effective throughout the nation or throughout the whole states of Nigeria. And also, when you obtain this protection order, there is no time limit as to when the order will expire. And when the application is made, the court shall as soon as possible consider the application. Also, by virtue of the protection order, you can also make someone that wants to commit, for instance, domestic violence, not to commit that domestic violence. And where the protection order is gotten, the person who the protection order is given against, if the person violates that order, the person also commits an offense, which on conviction will be liable for a term of imprisonment of 6 months, or better still, a fine of 300,000. Now, this is the sections. The sections in the Violence Against Persons Act are really very much, like I said, from section 1 down to section 46. But for the purpose of this video, these are the sections I consider necessary for you to know. So if you think you want to go through the other sections, you can go to the market or you go online, you get the sections of the Violence Against Persons Act. But for now, these are the sections that are necessary for you to know. Well, if you ask me, I will say the Violence Against Persons Act is really a very nice law. It's a good law. But the thing is, Section 27 of the Violence Against Persons Act provides that it is only the Federal Capital Territory that shall have jurisdiction to hear any matter or application brought under this act. To me, I feel like the act is for people in Abuja, because if things are committed, for instance, someone is suffering from domestic abuse here, maybe in Lagos or in Port Harcourt, you have to go to Abuja in the Federal Capital Territory, like the Federal High Court of the FCT, to be able to bring an application under this act. However, wherever a judgment is given, it's sustainable and is applicable to all the states in Nigeria. But for you to go for a trial, you have to go to Abuja. What this means is that if you're not resident in Abuja and anything is done or any actions are made with respect to the Violence Against Persons Act, and you want to bring up an action under this act, you must go to Abuja to do so. In my opinion, this is a fundamental flaw, and it will reduce drastically the resultant effect of this act. They should have just tagged it Violence Against Persons Act living in Abuja. But I think they should amend Section 27 and give jurisdiction to the High Courts of all the states, or better still, Federal High Courts of all the states, other than making it just in Abuja. What do you think about this act? Please let me know your opinion about this act. Thank you very much for staying tuned in my video. See you on my next video. Bye.